So dear students, today we will take up the writ of quo warranto. We will study the legal requirements and ingredients of writ of quo warranto and its meaning also. And after understanding the provisions of law relating to writ of quo warranto, we will draft a writ of quo warranto also. Dear students, the object of writ of quo warranto is to prevent a person who has wrongly usurped a public office from continuing in that office. This writ calls upon the person assuming the public office wrongfully to show cause to the court under what authority he holds the office. You see, we have a very glaring example of writ of quo warranto, where one person of Assam Legal Services was appointed as law secretary. Then he was elevated as High Court judge. He was neither an advocate nor a district judge. A writ of quo warranto was filed against him and he was removed from his post. So dear students, this writ of quo warranto cannot be filed against a suppression of a private office. The office must be public office. Another leading authority is State of Assam versus Kusheshwar Sekia. This case was decided in 1970 by the Supreme Court, and in this case, appointment of additional district judge was successfully challenged. Dear students, I'm sure that many of you will become civil judge junior division or metropolitan magistrate in metropolitan areas. I may tell you that your appointment as metropolitan magistrate or civil judge junior division can be challenged in a writ of quo warranto. These are the few articles of Constitution relating with the appointment. Article 233 relates with the appointment of district judges by the governor of that state in consultation with the High Court. Then district judges are also appointed in higher judicial services if they have 7-year practice as an advocate or they are promoted from civil judge senior division. Then Article 233 capital A deals with the validation of appointment of district judges, and 234 relates with the recruitment of persons other than district judge to the judicial services. And those appointments are made by governor after consultation with the State Public Service Commission and the High Court of the state. So your appointment as civil judge junior division will be conducted in accordance with Article 234 of Constitution of India. Then dear students, now we move on to the actual drafting of writ of quo warranto. And you will have to decide first whether you are going to file this writ in the High Court or in the Supreme Court. If you will file writ before High Court, then it will be under Article 226. And if you are going straightway to the Supreme Court, then it will be under Article 32. So first of all, while drafting a writ of quo warranto, we have to select the name of the court. And name of the court, here we have selected in the Honorable High Court of Judicature at Allahabad, UP. In the bracket, we will write down original civil jurisdiction. You know that the writ jurisdiction of the High Court is their original jurisdiction. Then you will write down writ petition number dash dash of the year. Year you know, but petition number you do not know at the time of filing it, because the petition number is allotted by the court computer after you file it. So writ petition number dash dash of 2019. Then petitioner's name, parentage, complete address is to be mentioned by you. So our petitioner here is A, son of B, resident of flat number 52, Alambagh, Lucknow, UP. He is the petitioner. And versus other party is AB, son of CD, resident of flat number 54, Alambagh, Lucknow, UP. He is our respondent number 1. And respondent number 2 is XY, son of YZ, resident of 58 Alambagh, Lucknow, UP, presently Chief Minister of UP. And third is Governor of UP. So we have these 3 respondents in this writ petition. One petitioner, 3 respondents. Let us see how the writ of quo warranto is to be drafted against these 3 persons and what are the facts. So heading is petition under Article 226 of the Constitution of India for the issue of the writ of quo warranto. To whom you are addressing this writ, you will have to draft. So to the Honorable the Chief Justice and his companion judges of the Honorable High Court. So this writ is addressed to Honorable the Chief Justice and all his companion judges. Why you are addressing to the full court? Because you do not know before whom your writ is going to be listed. So that's why you are addressing to Honorable the Chief Justice and all his companion judges of the Honorable High Court. The above named petitioner most respectfully submits as under. Now let us see what is the submission of the petitioner. Para 1, that the petitioner is a taxpayer and a voter of Lucknow City Central Constituency for UP Legislative Assembly. This is fine. That petitioner is a resident of Lucknow and he is a taxpayer and a voter of Lucknow City Central Constituency for UP Legislative Assembly. Para 2, that respondent number 1 is an illiterate person who contested in the general elections held in November 2018 for the membership of UP Legislative Assembly from Lucknow City Central Constituency, but he lost the election. So respondent number 1 lost the election for MLA. Para 3, that the respondent number 1 was appointed as law minister in the government of UP by respondent number 3, the governor of UP, on the recommendation of respondent number 2, the chief minister of UP, on 6 January 2019, as published in the UP Gazette, dated 6 January 2019. And respondent number 1 took the oath of office of law minister on the same day. You see, a losing MLA who has lost the election is now being appointed as law minister in the state. We have to see the legality of the appointment of this MLA as law minister. Para 4, that the respondent number 1, losing MLA, was not a member of either houses of legislature of the state of UP at the time of his appointment as law minister. You know, legally anybody can be appointed as minister even if he is not member of either house, but within 6 months, constitutionally within 6 months, he has to become member of either house of the Legislative Assembly or Legislative Council. Para 5, that respondent number 1 was nominated as member of UP Legislative Council on 6 January 2019 by the Governor of UP under clause 5 of Article 171 of the Constitution of India on the advice of respondent number 2. Now see, he has to be inducted into the membership of the either house. So on 6 January 2019, he was nominated as member of UP Legislative Council by the Governor of UP on the recommendation of Chief Minister in accordance with Article 171. Para 6, that the respondent number 1 is an illiterate person and he does not possess any special knowledge or practical experience in the field of law, literature, art, cooperative movement, or any other social service. See, the requirement of Article 171 is that a person can be nominated to Legislative Council provided he has special knowledge or practical experience in the field of law, literature, art, cooperative movement, or any social service. Para 7. That respondent number 1 is an influential person and leader of his community in the state of UP, and a large number of voters, being more than 40% in the constituency of respondent number 2, belong to the community of respondent number 1. Meaning thereby, a person who has lost the election, you are inducting him into the Legislative Council. You have appointed him as a law minister just to catch the votes of his constituency, where he has a control over more than 40% of the votes. Para 8. That the respondent number 2 got the respondent number 1 nominated to the Legislative Council of UP in spite of his defeat at the said general election of MLA, with a view to utilize his influence and influence of his community for securing votes in the next general election. That is the reason. To catch the votes of his community, you have nominated a lost MLA who has lost the election. You have inducted him as member of Legislative Council and you have appointed him as a law minister. Para 9. That in criminal appeal number 213 of 2018 in the case of state of UP versus AB son of CD. This AB son of CD is the MLA who is appointed as law minister. Resident of flat number 54 Alambagh, Lucknow, UP. This honorable court was pleased to make an adverse remark against the respondent number 1 regarding his bad character. And this appeal was filed by the state of UP, challenging the acquittal of respondent number 1 in a case under section 376 and 302 of IPC, PS Alambagh, Lucknow. See the character of the law minister appointed by the state of UP, that adverse remarks were made against him in a case of rape and murder. Para 10. That the said nomination of the respondent number 1 to the UP Legislative Council by the opposite party number 3 and his appointment as law minister in the UP government are quite illegal, and he has no right to become a member of UP Legislative Assembly and to hold the said office of law minister. Why? Because he does not possess special knowledge, and High Court had made a remarks against him in a case of rape and murder. Para 11. That the petitioner, being a voter and conscious citizen of India, is interested in not only allowing the Constitution of India to be subverted in the personal interest or in the party interest by anybody, and begs to prefer this writ petition inter alia on the following grounds. Now let us see what are the grounds of this petition. After a narration of facts, you are supposed to mention the grounds. So ground number 1. Because the respondent number 1 is an illiterate person, he does not even know how to sign his own name. He puts his thumb impression on all the documents instead of his signature. So first ground is that the law minister is an illiterate person and even he does not know how to write down his own signature. He puts his thumb impression on all the documents. This is ground number 1. Second ground is because the respondent number 1 does not possess any special qualifications as provided in clause 5 of Article 171 of the Constitution of India. Thus, his nomination to the UP Legislative Assembly is ultra vires of the Constitution of India. This is the second ground, that the law minister appointed by the state of UP does not possess special qualification as required by Article 171 of Constitution of India. Hence, his appointment is ultra vires of the Constitution. Hence, we are challenging this appointment under writ of quo warranto. Third ground is because the nomination by the governor of UP under clause 5 of Article 171 of Constitution of India has been designed to introduce only those persons in the legislature who do not seek election but have special knowledge or practical experience in the field of literature, science, art, cooperative movement, or social service. And such nominations are done in the public interest. But the respondent number 1 does not possess any such qualification, and his nomination is totally against the Constitution of India and is as such void ab initio. Fourth ground, because the use of a constitutional provision to introduce a defeated candidate in the legislature by backdoor with ulterior purpose of catching votes in future elections for the purposes of inducting respondent number 1 or continuing him in the ministry is a fraud on Constitution of India. This is next ground, that you are committing a fraud on Constitution of India by inducting a defeated candidate in the legislature by backdoor. Fifth ground is because the appointment of respondent number 1 as law minister and his nomination to UP Legislative Council are malified and bad in law. Now comes the prayer. What is the final prayer? Therefore, the petitioner most respectfully prays that this honorable court may be pleased to issue a writ, order, or direction in the nature of quo warranto against respondent number 1, requiring him to show authority under which he holds the office of member of UP Legislative Council and the office of law minister of UP government. B. To issue any other writ, order, or direction as is deemed fit and proper in the circumstances of the case. And third prayer is allow this petition with cost. Place you will have to mention where you have drafted this petition in Lucknow. Date of filing you are supposed to mention. Date of filing is 10 January 2019, and signature of petitioner are also required. And since this petition is drafted and to be submitted through counsel, so you will write down through counsel for petitioner, and you will again obtain the signature of ABC advocate also, who is going to file this petition before the Allahabad High Court. So dear students, this is how we draft a writ of quo warranto to be filed before the High Court or Supreme Court. And the meaning of quo warranto is that the person who is holding the office will have to show by what authority he is holding the office. Otherwise, he will have to quit that office. So this is in a nutshell the theory and drafting of a writ of quo warranto.